Okay, clip this on.
Yes.
Okay. Okay, after I administer the oath, the General Counsel will begin questioning the witness, and then the floor will be open to commissioners for questions. Commissioners will have 5 minutes to ask each of their questions of the witness, and we will again proceed in order of seniority, the only difference being that we've swapped out Commissioner Gaziano for Commissioner Kirsnow. At that point, we will engage in another 5 rounds of questioning if time permits. Mr. Perez, please raise your right hand. Do you swear and affirm that the information you're about to provide is true and accurate to the best of your knowledge and belief?
Yes, I do.
Thank you, sir. Given your limited time here today, we ask that you adhere strictly to the 5-minute time limit for your testimony.
Okay. Good morning, Chairman Reynolds and members of the Commission. Thank you for the opportunity to testify here today. The Civil Rights Division remains committed to upholding the civil and constitutional rights of all individuals, particularly those who are the most vulnerable members of our society. I am pleased to be here today to discuss one of the cornerstones of the Division's work, our enforcement of federal laws to protect voting rights. Protection of the right to vote is one of the Department's top priorities, and we want to be as responsive as possible to the Commission's requests for information about our law enforcement activities in this area. To that end, the Department has responded to interrogatories and document requests it has received and has provided more than 4,000 pages of documents relating to our enforcement of Section 11B of the Voting Rights Act, and specifically with respect to the Department's litigation in the new Black Panther Party matter. Those documents include declarations received by the Department from witnesses in the litigation, as well as detailed information collected by the FBI regarding the events that gave rise to that case. As noted in the written responses to the Commission's inquiry, we have endeavored to be responsive to the Commission's requests while at the same time protecting against disclosures which would undermine well-established and long-standing confidentiality interests that are integral to the discharge of our law enforcement responsibilities, particularly those relating to litigation decisions. At the outset, let me emphasize with respect to Section 11B decisions that these are hard cases. Very few such cases have been brought. In fact, we can find records of only 3 cases filed by the government under Section 11B since its inception. The standards of proof are high, and as in every case, the question to be addressed is whether the evidence is sufficient to sustain the burden of proof. And on that question, reasonable minds can differ and can look at the same set of facts but draw different conclusions regarding whether the burden of proof has been met. Let me give you a few examples to illustrate that point. In the most recent case under 11B to go to trial, United States v. Brown, the court found that the publication in a newspaper by a county political party chairman of a list of voters to be challenged if they attempted to vote in the party primary did not amount to intimidation, threat, or coercion under 11B. In another case, in Arizona, a complaint was received by a national civil rights organization regarding events in Pima, Arizona, in the 2006 election when 3 well-known anti-immigrant advocates affiliated with the Minutemen, one of whom was carrying a gun, allegedly intimidated Latino voters at a polling place by approaching several persons, filming them, and advocating against printing voting materials in Spanish. In that instance, the department declined to bring any action for alleged voter intimidation, notwithstanding the requests of the complaining parties. In 2005, the division received allegations that armed Mississippi state investigators intimidated elderly minority voters during an investigation of possible voter fraud in municipal elections by visiting them in their home, asking them who they voted for, in spite of state law protections that explicitly forbid such inquiries. Here again, the division front office leadership declined to bring a voter intimidation case in this matter. This is the matter referenced in a recent GAO report that examined a number of cases brought by certain sections of the Civil Rights Division during the Bush administration. Moving to the matter at hand, the events occurred on November 4th, 2008. The department became aware of these events on Election Day and decided to conduct further inquiry. After reviewing the matter, the Civil Rights Division determined that the facts did not constitute a prosecutable violation of the criminal statutes. The department did, however, file a civil action on January 7, 2009, seeking injunctive and declaratory relief under 11B against 4 defendants. The complaint alleged that the defendants violated Section 11B because they attempted to engage in both voter intimidation and intimidation of individuals aiding voters. Although none of the defendants responded to the complaint, the department had a continuing legal and ethical obligation to ensure that any relief sought was consistent with the law and supported by the evidence. Based on a careful review of the evidence, the department concluded that the evidence collected supported the allegations in the complaint against Minister King Samir Shabazz. The department therefore obtained an injunction against defendant King Samir Shabazz, prohibiting him from displaying a weapon within 100 feet of an open polling place on any election day in the city of Philadelphia, or from otherwise violating Section 11B. The department considers this injunction to be tailored appropriately to the scope of the violation and the constitutional requirements, and will fully enforce the injunction's terms. Section 11B does not authorize any other kinds of relief, such as criminal penalties, monetary damages, or civil penalties. The department concluded that the allegations in the complaint against Jerry Jackson, the other defendant present at the polling place, as well as the allegations against the national New Black Panther Party and its leader, Malik Zulu Shabazz, did not have sufficient evidentiary support. The department reviewed the totality of the evidence and the applicable law in reaching these decisions.
Thank you, Mr. Perez. At this time, we'll hear from the General Counsel. Mr. Blackwood?
Thank you. Thank you for coming, Mr. Perez. If you could put up slide number 1. I'm sorry, 2. As I understand your testimony today, the main reason that the course of the litigation changed is that there was another review of evidence. There was, of course, a review of evidence beforehand in determining to file the lawsuit, correct?
Yes, there was a review between November 4th and January 7th.
Okay, and the time that the suit got filed, the J memo shows that 4 attorneys had signed off: Spencer Fisher, Christian Adams, Robert Popper, Christopher Coates. 4 line attorneys, or 4 attorneys, 2 of them, one of the chief, the other the deputy chief of the voting section. Were there new facts learned between the time of January 7th and May 1st?
The department has a continuing obligation in any litigation to ensure that the facts that are put forth to support, in this case, a default judgment, are in fact the facts that can support that judgment.
Sure.
And so that duty falls with not simply the line attorneys in the section, but people up the chain. And this case, in that regard, is no different than any other case where you have that continuing legal and ethical obligation to review the facts and apply the facts to the law as you have them.
Right, no question. Every attorney has that ongoing obligation.
And every supervisor has the obligation to review the work of the frontline people who are doing it. And
right,
that's standard procedure in the department.
No question. Now, but the question I do have is the one I posed to you, which is, was any new evidence learned from the time that the suit was filed on January 7th and the time that a continuance was asked on May 1st?
There was a continuing review of the evidence by people in the front office.
But no new evidence.
Well, there was a continuing review of the evidence.
Okay. Among that, though, was also a review by the appellate section, which occurred on, May 12th and May 13th, by Diane Flynn and Marie McElderry. That review and the memorandum resulting indicated no concern of the kind that you mentioned. If I could see slide 4, please. Ms. Flynn, in the memo that she prepared, and this was just before May 15th, which is the day the default was due, or the decision had to be made, she indicated we can make a reasonable argument in favor of default relief against all defendants, and probably should, given the unusual procedural situation. Who overruled Ms. Flynn's opinion?
The judgment in this case to proceed in the way that was chosen was made by Steve Rosenbaum and ultimately by Loretta King, based on a review of the totality of the circumstances. As it related to the National Party, the determination was made, as you know, there's no vicarious liability when incidents occur.